Finally, Arvind Kejriwal got interim bail from Supreme Court in Delhi excise policy. While giving the bail, the Supreme Court given some observations. What are those observations? What are the different types of bails? And what is the difference between the bailable and non-bailable offence, and bail, parole and probation? What are the key differences? Apart from that, we will also discuss about why this particular case Supreme Court allowed the bail to Arvind Kejriwal, and what are the observations made by the Supreme Court, while we will discuss about some counter arguments made by the Solicitor General as well. So these are the details we are going to discuss in this particular video. Apart from that, we will also discuss about the process. What is the difference between the conviction and arrest, and what are the provisions related to arrest and conviction? We will discuss. First, let us go to the context. Supreme Court allowed interim bail to Delhi CM Arvind Kejriwal till June 1st. This is the main thing regarding this video. So first we have to understand what is this interim bail. Normally bail, first you have to understand bail. So here, when a person commit any offence, after a person committed any offence, the police will arrest. Okay, arrest happens obviously. Here, based on this offence, generally there are two types of offences: bailable and non-bailable offence. Non-bailable offence, non-bailable and bailable offence. Bailable. If it is a bailable offence, obviously the person will get bail at the station house officer, from the station house officer itself. That means at the police station. Police station, they'll get bail. This is generally known as station bail. Non-bailable means there are two types of possibilities. A person may send to the custody under the judge, that is the judicial custody, or the person may be in the custody of police custody. And there is one provision, students, that is, once a person is arrested, the person has to be introduced before the nearest magistrate within 24 hours. Which article of the Indian Constitution is dealing with that provision? Next. So in the case of judicial custody and police custody, or in the case of this bailable offence, once the investigation is done, then charge sheet will be filed before the court. Charge sheet will be filed. Once the charge sheet is filed, then court trial. After the trial, the person will be convicted. Then the person will be sentenced. Sentenced is also known as imprisonment. Okay. Here, before the person is convicted, if the person would like to go out of the custody, or if the person need any relief from the custody, then the person will go for the bail. So that means bail always applicable before the conviction. But once the person is convicted, then he will go into the prison, or depends on the case, sometimes he will be penalized. But if you go to prison, then if you would like to come out of the prison, temporarily due to some health reasons or any family health, person's health reasons like that, then the person need to apply for the parole. So this is the key difference between the bail and parole. I hope you understood. Now the bail. So why the provision of bail is there? Sometimes there may be extraordinary delay in investigation. During the time, once the person given the primary details, then there is no need of that person presence there. The persons can be released on certain conditions. So the person will be released on the conditions, and those conditions are nothing known as bail. Now here, Arvind Kejriwal also released on bail. Okay, every person while releasing on the bail, they will be released on certain conditions. Those conditions same applies to Arvind Kejriwal also. Okay, what are the conditions in this? The conditions are Arvind Kejriwal, he has to furnish bond worth of 50,000 rupees with one surety, and he should not visit Chief Minister office or Secretariat, very very important, and he should not sign on any documents unless until essential, because in Delhi majority of the functions are required the final authority from the Lieutenant Governor. So before Lieutenant Governor, certain files require the signature from the Chief Minister. So in those conditions only he has to sign. Then he should not make any comments regarding the present case, of course, and he should not interact with any of the witnesses, or he should not have any access to any official files related to this particular case. So these are the conditions. Based on these conditions, he got the bail. And while giving the bail, Supreme Court given a remarks that, so that is, there is a very unprecedented delay between the registering of the case as well as arresting of the Kejriwal. The case was registered on August 2022, okay, and the Arvind Kejriwal arrest took place in March 2024. So why this delay? And the questioning of the arrest, the timing of the arrest is also questionable, because that is just before the election. And previously Arvind Kejriwal did not commit any kind of proved crimes, okay. That means he don't have any criminal and precedent. So by considering all these things, Supreme Court given the interim bail. Of course, it was objected by the, counter-argued by the Solicitor General. They argued that if Arvind Kejriwal is just by considering a national leader and he has to participate in the political activity, and those are the reasons for giving the bail, then Amritpal Singh is also claiming for the bail because he would like to contest from the election. Then Supreme Court clarified that there is a significant difference between the Amritpal Singh and Arvind Kejriwal, because Arvind Kejriwal is a state chief minister and leader of the national party. He don't have a previous criminal record. That is the reason we are giving interim bail. And of course, while the interim bail is given, the Supreme Court was requested by the government that means the lawyers, that he should not be allowed to participate in any political activities. That is also overturned by the Supreme Court. Supreme Court quoted the two cases, okay, such as Siva Shankar Das versus State of Odisha and the State of Andhra Pradesh versus Nara Chandrababu Naidu. In these two cases, the respective high courts given a bail on the condition that the people should not participate in any political activities. But in those two cases, those judgments given by the high courts, they were overturned, okay, they were cancelled by the Supreme Court. The same trend followed in this case also. So Supreme Court declined to the request of the Solicitor General. So Supreme Court allowed the Arvind Kejriwal to participate in political activities. That you have to know. And there are two types of offences, bailable and non-bailable. Generally, bailable offences are less serious. And even though the person is proven, generally the conviction will be less than 7 years. That means they are the cognizable offences. And they are the compoundable offence also. That means compromise can be reached between the two parties in the crime. Next, non-bailable. Generally, they are serious offences. Conviction can be more than 7 years. These are non-compoundable. Compromise cannot be reached between the parties. Generally, we will see sometimes in a sexual assault case, there will be compromise made between the parties by the village heads and all these things. Actually, they are non-compoundable offence. In non-compoundable offence, if any person tried to bring any kind of compromise, that is also an offence that we have to understand. Bail. The term bail actually derived from the old French verb bailer, which means give or deliver. Bail is generally conditionally releasing a person under the legal custody by taking a promise that the person will appear in the court whenever court requested him to attend. And it is also signifies that certain security deposited before the court for the release. So this is regarding the bail, interim bail. Okay. So here, let me explain. When a person is arrested, obviously at one point of time, he'll get bail. And before this getting the regular bail, if the person require any interim relief, then they can go for the interim bail. Sometimes before arrested also, person can request for the bail. That is known as anticipatory bail. Okay, anticipatory bail. These are the differences: anticipatory bail, interim bail, and sometimes what is happening, generally to get a bail, the person has to provide certain amount of the surety and all these things. Sometimes people don't have that facility because of lack of money, there are no surety and all these things. Because of that, they remain as under trial. Always remember, under trials are not convicts. They are still facing the investigation or trial. Okay. Under trials, if they finish half of the time in jail, okay, in jail, in whichever the case they are arrested, then obviously they should be given the bail. They should be given the bail. Very, very important. What does it mean? For example, a person arrested for a crime, and for that crime the person will get 6 months of punishment. And in this case, he is already in 3 months in jail and still he is not proven guilty. In this kind of condition, he will be released automatically. That is known as default bail. Or statutory bail. Generally, in the non-cognizable offences or any less serious offences, after 60 days the person will get the default bail. If it is a serious offence, obviously the person will get the default bail after 90 days, depends on the case. Okay. And I explain interim bail, and interim bail will be given based on the nature and gravity of the accusation and the criminal history of the accused person, in this case Arvind Kejriwal, probability of the accused escaping from the justice or going to another countries, possibility that the intention behind the allegations and the person, they are only to injure that person. That means some malicious intentions are there. So based on these conditions, a person will be given the interim bail. Next, anticipatory bail. According to section 438 of the CRPC, generally anticipatory bail will be given by the Sessions Court or the High Court. Anticipatory transit bail. This is applicable only when a person is arrested by other state police, not their own state, other state police. Then anticipatory transit bail applicable. Default bail, already told you, under section 167 clause 2 of the CRPC. Generally it is 60 days and 90 days. 90 days in case of the death or life imprisonment. In this kind of serious cases, 90 days is the required time limit for the default bail. The difference between the bail, parole and probation, already I told you. Parole is generally applicable to a person who is convicted already. Parole will be given by the parole board. And when a person is under parole, the person will be under supervision. Probation is generally related to the first time offenders. They won't sent to the prison. They will be recommended to the community service. After the community service, they will be released. Okay, this is also under supervision. Whereas a bail, it is before the trial is finished, before the person is convicted, bail is applicable. That is the main difference between the bail, parole and probation. And already conditions I already told you. Conditions for bail in bailable offence and conditions for bail in non-bailable offence. It may be the woman or child, in case of lack of proper evidence, in case of delay in FIR. In this particular case, delay in FIR is also one of the basis for this interim bail to Arvind Kejriwal, if the accused is gravely sick in this kind of conditions. And constitutional provisions related to right to life, right against conviction, right against arrest. These are the article 20, 21 and 22. And way forward. The way forward is, in India unfortunately there are no uniformity in bail laws, because bail comes under the prison and the prison comes under the state list. Because of that, different states are having the different laws related to bail. Previous former CJIs at different point of times, they advocated for uniformity in the bail laws. There is a need of the hour. And we focus on the victim rights, and smart policing is the need of the hour. Increasing the inclusiveness in the public force, and this indiscriminate arrest based on the caste, class and community, that should be avoided. These are the way forward. Next, what is the Cas9 protein that is often mentioned in news? It is related to molecular scissor used in targeted gene editing. Next, today's video question is, with reference to India, consider the following statement. Judicial custody means an accused is in the custody of the concerned magistrate and such accused is locked up in the police station, not in jail. Observe this carefully. Second, during judicial custody, the police officer in charge of the case is not allowed to interrogate the suspect without the approval of the court. Okay, by taking the approval of the court, then only they can interrogate when the person is under judicial custody. Means A large number of poor, Dalit and people from minority community, they are still languishing in jail as under trials because they are not unable to fulfilling the bail conditions. How can speedy dispensation of justice can be ensured under this under trials? Comment. Okay. So in these kind of conditions, how the speedy justice can be delivered? As we reach to the end of this video, quick revision. In this video, we mainly discussed about different types of bails and conditions in Arvind Kejriwal bail. What is the difference between the anticipatory bail and regular bail? Bailable and non-bailable offence, parole. We discussed about that. And so in which condition, by considering what condition a bail will be given to the person. So these kind of topics we covered in this particular video. I hope this video is useful to you. Thanks for watching this video. Have a great day. Jai Hind.